The New York Times recently printed a story titled, "Transgender Could Be Defined Out of Existence Under Trump Administration." The explosive headline took off, leading people to debate whether this was the total erasure of the trans identity, or just not a big deal. However, as it is often the case, the media missed what was truly important about the story. So let's dive in and find out what this all really means. The New York Times claim they have a leaked memo from the Department of Health and Human Services, where they are pushing for a legal definition of sex under Title IX of the Civil Rights Act. Sex means a person's status as male or female based on immutable biological traits identifiable by or before birth. So what's that mean? Well, Title IX is a law that prevents any school that receives public funding from discriminating against people on the basis of sex. Now, the Obama administration issued guidelines under Title IX that included transgender students as being protected under sex-based discrimination. This meant that schools would have to recognize a student's transition status. So a transgender boy would have to be allowed to take an all-boy class, participate in male sports, and use the boys' bathroom or locker room. However, in 2017, the Trump administration removed the Obama administration inclusion of transgender from Title IX. This means that even before this leaked memo came out, schools were no longer legally required to recognize a trans student's transition. So if this already happened last year, what is the panic about now? The concern is that if the Trump administration specifically defines sex the way they want, that would have further-reaching implications beyond Title IX, and possibly affect other legislation. So, is that a valid concern? Unfortunately, there are some rather large problems with the New York Times article that makes determining that difficult. On several occasions, the article uses the term sex and gender interchangeably. Is this a mistake on the author's part, or does the memo do the same? We don't know, because the big problem with all of this is that the New York Times hasn't actually released the memo. So we only have the Times selected quotes and interpretation to go on, which leaves the two most important questions unanswered. Would this only apply to Title IX, or would it apply to other laws? And how exactly does the Trump administration plan to change this? By simple presidential order as Obama did, which would mean any future president could simply change it back? Or do they intend to push for legislation or a court opinion, which would make the change more permanent? Unfortunately, in regards to this specific memo, we don't have a clear answer on any of this. But don't fret, I didn't make this video just to tell you we don't know. Remember what I said in the beginning, the media missed the most important part of this story. You see, there actually is a far more important issue right now that is directly related to this situation, and it's not being widely reported. The good news is that it's not reliant on a secret memo that we can't all read for ourselves. The bad news, depending on where you fall on this issue, is that the implications behind this are far more troubling for the entire LGBT community. On October 4th, Jeff Sessions, the now former Attorney General,
"You're fired,"
sent out a memo about Title VII of the Civil Rights Act. Title VII says that employers are not allowed to discriminate against or fire any individual because of their race, color, religion, sex, or national origin. Now, the point of Jeff's memo was to specify that Title VII does not protect trans individuals. You see, the Obama administration, as well as several lower courts, had interpreted the protection on sex discrimination to also include protection for transgender individuals. Jeff Sessions said that transgender status is not protected under sex discrimination because transgender is one's gender identity and not their sex. A distinction many trans advocates have been pushing themselves.
Sex is biological. Gender is how you identify yourself and your experience.
Now, originally I was swayed by this argument. It didn't make sense to me that a court could interpret sex discrimination to include transgender status. So I looked into one of the cases regarding this issue, which led me to a case where a transgender individual was fired from their job at a funeral home. After working there for 5 years, they began to transition from male to female, at which point the employer fired them for not conforming to the male dress code. And because they sincerely believes that the Bible teaches that a person's sex is an immutable God-given gift, and that he would be violating God's commands if he were to permit one of the funeral home's funeral directors to deny their sex while acting as a representative of the organization. Now, I must admit I don't remember the part in the Bible where they talk about transgender people, but that's just me. So the transgender individual is suing the employer under Title VII, claiming that they were being discriminated against by sex. So what happened? The courts found two things of note. The first is that Title VII's Sex Discrimination Clause does protect both trans and gay individuals because sex discrimination includes sex stereotyping. Let me explain. In 1989, the Supreme Court ruled on the case Price Waterhouse v. Hopkins. There, Waterhouse sued her employer, claiming she was continually not promoted or given a raise because she wasn't acting ladylike.
And here's how you sound.
And that the character traits her employer liked in men, they didn't like in women. The Supreme Court found that there was evidence to support this claim, and that sex stereotyping, or expecting individuals of a certain sex to behave in certain ways in accordance with their sex, constituted discrimination based on their sex. Thus, both gay and trans people would be protected under the sex category, as expecting or demanding an individual to be attracted to members of the opposite sex, or to have a gender identity that matches their birth sex, are both forms of sex stereotyping. And when this case went to the appellate court, they found it is analytically impossible to fire an employee based on that employee's status as a transgender person without being motivated, at least in part, by an employee's sex. Because if the employee was the other sex, they would not have been fired. As with this case, if the individual was exactly the same in all aspects, only born a woman, they wouldn't have been fired. Hence discrimination based on sex. This same line of reasoning also protects gay individuals. Now I found this line of reasoning convincing, and it changed my initial thoughts on the matter. So why am I telling you all this? Because this case, and other similar cases, including one where an individual is claiming they were fired for being gay, are all coming before the Supreme Court soon. And all these cases rely on the lower court's interpretation that sex discrimination also protects gay and trans individuals. And this is where the far more important story is. Because in October, the number 3 guy at the Justice Department, Noel J. Francisco, wrote a brief to the Supreme Court. In it, he basically says that the lower courts were all wrong to include transgender protection under sex discrimination, and that the Supreme Court should rule against it. Now, while the Trump administration has only directly stated their objection on the transgender issue, they are not ignorant to the fact that the exact same line of logic that protects transgender people from being discriminated in the workplace also protects gay people. You can't remove protections from one without removing them from the other. So right now, the Trump administration is arguing that employees should be allowed to fire people for being trans or gay. And that's what I meant when I said the implications affect the entire LGBT community. Now, there is a thought by some that issues relating to gay individuals' legal protection and equal treatment is already a settled issue. This shows that's not the case. Remember, it was only a mere 3 years ago that the Supreme Court ruled that gay marriage bans were unconstitutional. And it was only by a 5-4 margin. The 4 liberal justices, along with Anthony Kennedy, ruled in favor of gay marriage. The remaining 4 conservative justices ruled against it. So what's going to happen when these current cases go to the Supreme Court? The 4 liberal justices are all the same. However, the tiebreaker Anthony Kennedy is gone. Will either of Trump's appointees, Gorsuch or Kavanaugh, rule in a way to uphold gay and trans protections? I guess we'll just have to find out. So what will happen if the Supreme Court rules against gay and trans being included under sex discrimination protection? The good news for the LGBT community is that it will not affect gay marriage, will not affect hate crime laws, and will not affect any state or local laws that use the terms gender identity and sexual orientation. This will not erase or prevent transgender individuals from being recognized by the government. The bad news for the LGBT community is that this will remove federal protection from discrimination in schools, employment, and housing, meaning any of these things can legally be denied to someone because of their sexual orientation or gender identity. Now, there is one other major thing that will be affected by this change: medical treatment and insurance. If the Supreme Court rules against protecting gay and trans individuals under sex discrimination, it will mean doctors, hospitals, and insurance providers can all legally refuse to treat or serve individuals because they are gay or trans. And when I say refuse to treat, I don't mean only services related to transitioning. I mean any general health services. And medical insurance providers would be allowed to deny covering a person simply on the basis of being gay or trans. Now you may ask, can't Congress simply pass a law that adds protection for sexual orientation and gender identity to all these things? Yes, they can. Will they? Probably not. In 2013, Democrats in the Senate passed the Employment Non-Discrimination Act. This law would prohibit employee discrimination specifically on the basis of sexual orientation and gender identity. However, the bill died in the Republican-controlled House. Next year, the situation will be reversed. The Democrats will control the House and Republicans the Senate. Now, if we look at how the Senate voted in 2013, 10 Republican senators voted for it, and 32 against it. Of the 10 Republican senators, only 4 currently remain in the Senate. So I wager that it's very unlikely for the Republican-controlled Senate to pass any law created by the House that makes gay and trans discrimination in the workplace illegal. And even if it did somehow pass the Senate, we can only assume that Trump would veto it. Because despite what he said on the campaign trail,
Caitlyn Jenner were to walk into Trump Tower and want to use the bathroom, you would be fine with her using any bathroom she chooses.
That is correct.
it's his administration that's causing all of this in the first place. This puts gay and trans conservatives in a strange and uncomfortable position. Presumably they support conservative candidates for reasons unrelated to these issues, so it becomes a factor of what's more important, equal protections for yourself or your values. I don't have an answer. That's up to every person to decide for themselves. I wish you didn't have to make this choice, but unfortunately, this is the world we live in. Hopefully one day, we'll move past all this, and you won't have to choose between who you are and what you believe.
Well, you have extra sensitive hearing. Hear this! I'm telling. I said vacuum!